Well, good evening, ladies and gentlemen, and welcome to this important session on the Stephen Lawrence murder case. Fiat recti, let right be done. We in the UK are fortunate that we live in a country where the rule of law is one of the fundamental principles of our unwritten or uncodified constitution, and access to justice is a fundamental principle. No one is above the law, and everyone is equal before it. Unlike the situation in many other countries, our upholder of the law, the CPS, the Crown Prosecution Service, is independent and makes its decisions independently of the police and the government. Some of you will be familiar with the Terence Rattigan play, The Winslow Boy, in which the most sought-after barrister at that time in England, the King's Counsel, Sir Robert Morton, sacrifices the opportunity to become Lord Chief Justice in order to defend a schoolboy over the alleged theft of a 5-shilling postal order because he believed that right had to be done. The expert lawyer was doing the best to represent his client's interest. When Rattigan wrote in 1946, society was still hierarchical, deferential, and the expert was highly respected. So what has changed since then? Nowadays, there is a declining trust in expertise, epitomised by a statement by one cabinet minister before the Brexit vote 2 years ago, who claimed that the public had had enough of experts. Anti-intellectualism has been on the rise and can be observed in attitudes towards compulsory vaccinations, climate change, and genetically modified crops. In a world where the general public rely on social media for news and entertainment, the trust in experts is diminishing. If one can Google information about almost anything in an instant, people feel that they can obtain a definitive answer to any question without recourse to an expert. Tonight, we have as our speaker a person who was one of the most senior people in the CPS, charged with upholding the law in this country, subject to the designated criteria under which that organisation operates. We shall hear the consequences and ramifications of what can happen when people ignore the advice of the expert and claim that there is equivalence between their view and that of the expert with a lifetime's experience in their specialised area. Howard Youngerwood, who recently moved to Edgware and is now a member of our shul, studied law at King's College London. He initially practised criminal law, working in senior legal positions, firstly at New Scotland Yard and then in the Crown Prosecution Service. He's been involved in some of the most complex cases in the public eye. He was later appointed as a part-time immigration judge from 2002 to 2015. He has frequently performed in public as a pianist, both a soloist and accompanist, since the age of 8, and taken leading roles in Gilbert and Sullivan operas, though I understand you will not hear him singing from Trial by Jury tonight. We must leave it for another occasion to hear The Briefs Are Trooping Gaily, and Every Day My Voice Was Heard at the Sessions or Ancient Bailey. As an actor, he has appeared in a professional educational recording and on the amateur stage in leading roles in classical and modern drama, as well as directing. He has made frequent appearances as a public speaker and entertainer for charities. He has had articles published in the Daily Telegraph and for the Jewish Association of Business Ethics. I now have pleasure in inviting Howard Youngerwood to talk about his involvement in the Stephen Lawrence case, after which he has agreed to take questions.
Good evening to you all. Having shouted at my wife for 47 years, I believe I can project my voice, but there's always someone, isn't there? So if anyone's unhappy with the sound, I would assume that your hand gestures are not a comment on the lecture, but a request for me to speak up. Can you firstly briefly assist me by a show of hands? How many of you have seen any or all of the 3-part documentary on the murder case broadcast last April? Could I have a show of hands? Thank you very much. So, ladies and gentlemen, let's just draw back for a moment and consider, has there ever in our lifetime, and maybe even before that, been such a case as the Stephen Lawrence case, a case which has so impacted on popular culture, which has had such a searing effect on the emotions, which involved, to a degree never seen before, trial by the media rather than trial on the evidence. So much so that it was considered heresy, not my quote, heresy, to argue anything but for the conviction of these racist suspects on the basis of public opinion rather than evidence. A case which led to a massive multi-pound public inquiry and the publication of the famous Macpherson report, which has caused strong opinions on both sides. And speaking purely personally, it was a case which nearly ruined me and nearly ruined my family. But we have to ask ourselves what may seem a fairly obvious question. What exactly was it about this case which led to this publicity, which led to this inquiry? Was it because there was a wicked racial murder which went unsolved? Well, sadly, no. There have been other wicked racial murders in the same area of South London. There were 2 or 3 in the years immediately before this murder. That can't be the answer. Was it because there was an allegation of extreme police incompetence which led to a failure to convict? Well, allegations of police incompetence, as you probably well know, are hardly rare. That cannot be an explanation. Was it because we had a redoubtable mother determined to find justice and to fight for justice? Well, however brave she is and was, that again is not unique. You often see in the papers families who fight for year after year to get justice for their family. Was it because it's normal to have a public inquiry where there is an unsolved murder? Well, no, we don't have public inquiries on individual cases generally. We may have them for large-scale disorder, like the Scarman report on the Brixton riots, but this does not explain it. So, ladies and gentlemen, my view, and it is a view I've held for over 25 years, and I think it's based on the evidence, is that there's only one reason why this case has had the impact it has had. And that is that from virtually the start, the anguished family, their supporters, and their legal team went to the media and alleged that nothing could be explained in this case other than racism. Racism affecting everything from the start: failure to give first aid, failure to arrest, uncaring about the family, failure to convict. It was racism, in my view, which was and still is the leitmotif about this case to explain everything about the case. I've spoken frequently, or fairly frequently over the years about this case. There's been a long gap, and I've come out of the woodwork, as it is, because of this documentary. And I felt rashly or wisely that I had to speak out. And I want to make something very, very clear. Although this case has had an appalling effect on myself and my family, I have never once publicly criticized Mrs. Lawrence, now Doreen Lawrence, Dame Lawrence, for anything she has said. God forbid any of us should suffer the vicious murder of a loved child. It doesn't think bearing about. And frankly, you are entitled, are you not, in that situation to say anything you want, to make allegations against your fellow man, even God. It is natural. I do not criticize. But, and it is an important but, it is quite another thing to expect your anguished views to be automatically accepted and acted upon by the public. And sometimes your best friends in a situation of tragedy are those who say words to the effect, we share your agony, we share your anguish, but some of the things you have said are wrong. And some of the things you have said are unfair. And that basically, praising it, is my attitude to the allegations made by Mrs. Lawrence. Let me go back now. Now we'll be going a little bit, jumping forward and back, and I hope it'll make some sense. April 1993, over 25 years ago, was the date of this murder. In that year, somewhat after the murder, I was promoted to Assistant Chief Crown Prosecutor for casework, basically being in charge of casework quality for half of London. It was a big position. Earlier that year, I had been running a branch of the Crown Prosecution Service, and one of my teams in that branch, the juvenile branch, received the initial case papers in the Stephen Lawrence case and had an initial look at the papers. For all intents and purposes, within a very short time, for reasons I will briefly explain, but I haven't got too much time, I decided very unusually to take over the whole conduct of the case. As an Assistant Chief Crown Prosecutor, you become involved in decisions and taking crucial decisions. You do not take over the whole case. But being a Jew and perhaps used to rebelling, I decided it was necessary in this case. I took it over, and for some years I was in charge of it, so that when there were comments and criticisms in the press about the CPS, that meant, to all intents and purposes, me. My reputation at that time, it's important to state, well, I had a reputation of being a good lawyer. I also had the reputation of being a backbencher. Jews tend to speak out when they see nonsense. It's a bit like the emperor's new clothes. And right from the start, I had been critical of the way that this country, and only this country, could have introduced the Crown Prosecution Service with all the chaos that ensued. We had some wonderful lawyers, but the organization was chaotic. So I had the reputation of being a good lawyer, and also I had the reputation of being a proud and passionate Jew, with all that involves. I, like many of you and others, had family murdered in the war, and that had affected me and scarred me. So I was, I suppose, this image of a verbose practicing Jew who happened to be a good lawyer and was also critical of the CPS, a bit of a difficult fellow to put up with. But you would have thought, would you not, that one thing I should not have had to worry about was being accused of being a racist. Well, the world's a funny place. Now, I'm going to give you a very brief lecture, not to show off, because you need to understand 2 or 3 factors which are very important about this case. And we are talking about 1993. Some important things have changed, other things have not changed. Now, first of all, the most vital thing for you to understand is in 1993, if you were acquitted of any criminal charge, whether a minor charge or even murder, that was it. If the prosecution the next day found wonderful evidence which would be bound to convict anyone else on any other day, hard luck. If a defendant was acquitted of murder and came out of the trial and said, "I've been acquitted, in fact, I've done it, and you can't touch me," he would have been absolutely correct. So you don't need to be a great lawyer to realize that taking a prosecution, a public prosecution, as well as a private prosecution, which happened in this case as well, it was absolutely vital to make sure that you had evidence in which you were pretty sure you were going to succeed. Because if you did not, there would be no justice for the Lawrence family, no justice for the public. It is as dire as that. Secondly, we have in this country, for serious cases, a system of trial by jury. And what that means, the normal rule, is simply this. If the prosecution bring a case, and at the end of their evidence, the judge considers there is prima facie evidence. In other words, a jury could convict on that evidence. They're not bound to, but there was just enough evidence for them to consider. Then it goes to the jury, and the jury make up their mind for better or for worse. You win some and you lose some. There are, however, vital to understand in this case, some important exceptions. And the most important exception is in relation to identification evidence. Because over the years, there have been so many cases of miscarriages of justice where people have been certain that they have recognized someone or correctly identified a suspect, and that has proven not to be the case, special rules were brought in. And those rules, in a sentence or two, were simply this. If the trial judge considers that the quality of the identification is weak, and there is no other evidence tending to confirm it, then in that case, it does not go to the jury. The judge stops it, end of case. What do we mean by weak identification evidence? 2 quick examples. Something seen in what's called a fleeting glimpse. It's all over in a half a second, and someone says, "Oh, I saw a half a second, I'm sure I can identify." Weak. Or an identification in longer circumstances, but in poor quality. It may be from a few hundred yards away, or it's a foggy day. So vital to understand, it's so relevant to this case, it does not go to the jury where you have weak identification evidence. Third little lesson, well, what can the prosecution do? I'm talking now about the Crown Prosecution Service. If they have weak evidence, well, they cannot carry it on. The duty is you only carry on where you have what's called a realistic prospect. But that is not the end of the day, because they have and had a very simple procedure called discontinuance. Discontinuance means you stop the prosecution. That is not an acquittal, and it means that you play for time, if at all possible. So if you get the evidence after you have discontinued a case, you can then start again, and there is no problem whatsoever in that. And I use that several times, sometimes in some very big cases, and where some people are very unhappy. Some of you may recall the very tragic murder of Police Constable Dunn by a suspected drug dealer. This is also about 25 years ago. I got the evidence. The evidence was far stronger than in the Stephen Lawrence case. I thought we might succeed, but it wasn't, in my view, quite enough. And much more importantly, I foresaw, for technical reasons which I can't remember now, that we were likely to get some further evidence which would make sure that we would get a conviction. When I told this to the police, who'd lost a colleague murdered in cruel circumstances, that I was going to discontinue it, they were not happy with me at all. Cut forward some years, we got the evidence, it was more years than I thought, and the same suspected drug dealer is now serving life for that murder. So discontinuance is a sensible way to proceed. Right, end of legal lecture. Now, I decided when I saw the evidence, and I haven't got time to go through it, that this case, which involved identification evidence by Stephen Lawrence's friend Dwayne Brooks, was in terms hopeless. And I'm not going to go into it because that view has been fully supported when the private prosecution collapsed for exactly the same reasons at the Central Criminal Court, when the Macpherson report confirmed my views. And over 25 years, I can tell you that apart from Messrs. Michael Mansfield and Imran Khan, I use the word Messrs. Deliberately, no lawyer, to my knowledge, has disagreed with my views. The evidence on identification, sadly, was hopeless. It's not a matter of criticism. It is a matter of fact. So I decided what to do. We would discontinue and hope that we would get the evidence. Police, right from the start, were of the view, and having later looked at the evidence, I agreed with them, that there were a few people who could have given evidence against some of the suspects, but were too cowardly or too evil, frankly, to come forward. So we always had that hope, and we always had the hope that somehow forensic evidence would come, and many years later, it did come. You will know, many of you, that about 5, 6, 7 years ago, convictions were secured against 2 of the suspects because of the progress that had been made in forensic evidence. So my decision to discontinue made sense, and we hoped. And I decided to take over the case because I could see the public rumblings. Rumblings is a poor word. It was an explosion of anger when I discontinued it on patently sensible grounds, and the allegations of racism, like Pandora's box, then surfaced. The CPS, by that time me, were racist, the police were racist, and ladies and gentlemen, you also have to accept that the anguished allegations by this family also involved allegations against the state. It wasn't just simply the police involved in the original inquiry. It wasn't simply just the CPS. It was also basically the state. And that becomes quite clear when you see allegations made by the family at the time of the private prosecution that the state were involved in getting a judge to stage a dismissal. They'd got him in to make sure that this family would not be able to get justice. If I find the quote, I'll give that to you in a moment. So the allegations went right through from the beginning to the end. And those allegations, that poison, if I may say, are still with us today. If you look at the documentary, the lawyers in this case, who by now should frankly know better, are still making the allegations that the state did not care. They simply expected, to use their own language, the family to roll over and do nothing about it. So after all these years, the allegations are there, even though on a simplistic basis, on any objective basis, not just me, it is overwhelming opinion from experts that the identification evidence from the outset was simply too weak. So I then took over the case, and I spent some years looking at it. I first of all checked suspect, frankly, that police had been following up leads, because some of the allegations were the police couldn't be bothered. Well, there are criticisms to be made, and I will be making some of them, about police conduct, especially in the beginning of the case, but the allegation that they couldn't be bothered is simply not fair. I looked at every single message. Police were following up leads, efficiently or otherwise. They were active, and it's clear to me they wanted the prosecution to succeed. They were even trying to persuade me to run the public prosecution on evidence which was patently too weak. And during those years, I not only did that, but I became involved more than most cases. In most cases, a prosecutor does not become involved in the police role. He looks at the police evidence and then judges it. Here, I was working cheek by jowl by senior officers, both in the first team and then the second team the later year. And that meant actually being involved in advising them on initiatives, covert operations. Many of you, especially if you've seen the documentary, will know or recall that police secured evidence from 4 of the 5 suspects when they put in a video and audio probe in one of the homes. Now, it's quite clear these suspects twigged that they were being overheard. They almost certainly didn't realize they were being filmed, and then there's this awful video which I advised on and I approved to show that they were the most appalling racists. That by itself was not enough to establish identification at that time. It certainly established they were racist, but nothing more. But that video achieved a phenomenal amount of publicity. It's shown several times in the documentary. That was one of the things I did with police, advising on them. And we looked at other initiatives. Cars were bugged. Other people who had been acquitted of charges and who knew the suspects were approached. And I even took a big gamble. It didn't ultimately come up, but just to show you the efforts I was putting in, and it's all in the report. What I'm saying is not my views, it's all there to be read. We took the view that one of the 5 suspects was almost certainly involved, but almost certainly was not the person who stabbed Stephen Lawrence. Stephen Lawrence was stabbed to death. And we took the view that he was possibly a weak link who could be approached. And this is where I behaved with either a lot of imagination or maybe not, depends upon your view. At that stage, we were not getting anywhere. People were not coming forward. We hadn't secured any further identification evidence. It had come to a stop. And I discussed with the police this idea. What happens if we go to this suspect, who almost certainly was not the person who stabbed Stephen Lawrence, and say words to the effect, tell us who the stabber was, and we will forget about your involvement. One doesn't do that easily. He was involved, and you may say that's a wrong step to take. The person who did the stabbing perhaps is even more evil than the others, but they were all evil. But we were not getting anywhere. Now, police agreed with me. My problem was I had to persuade national headquarters, Director of Public Prosecutions, to really go on an approach which involved giving immunity. There's almost immunity. Well, it took me nearly a year. And finally, they agreed. And so we approached this suspect, and for about a week or so, we thought maybe we've got a prospect of progress, because this suspect sacked his solicitors then acting for him. His other solicitors were receptive, and then for whatever reason, the thing collapsed. We got nowhere. I'm just giving you some examples of how for several years I was involved underneath the radar, working with police, trying to set these initiatives. And the almost Kafkaesque, surreal situation was this. During those 2 or 3 years, the family had appointed, as you know, Michael Mansfield and Imran Khan to be their legal representatives. They were doing their best by trying to persuade me to launch a public prosecution, and ultimately by themselves launching a doomed private prosecution. They were doing their best on any objective basis to make sure that the Lawrence family would never get justice, because, to remind you, once an acquittal, always an acquittal. But they were considered the heroes. Whereas I, working under the radar with police to try and get evidence to secure justice, I was the villain. I was uncaring. I was racist. And these allegations of racism for a time were anonymous because they were referring to the Crown Prosecution Service. That all changed in 1996 when the Observer did what can only be called a marvellous hatchet job on me. They must have been planning this for, I should think, a few months. Basically, they were simply saying, at that time, they named me as the person in charge of the case. You can imagine what the public who didn't know me would think. They were saying that not only did I not care about alleged racism in my own branch of the Crown Prosecution Service, where we had nearly 40% from ethnic minorities, but, get this, I was going out of my way to totally get rid of, ruin the credibility of the only identification witness, Mr. Dwayne Brooks, by attacking his credibility and securing evidence against him, to be against him, so he would not be in favour. So, in other words, I was being portrayed as not simply a hypocrite, but a liar and a racist. And I had to decide what to do about that. And I remember thinking that if they just merely called me an idiot, that might have hurt, but almost certainly I would have done nothing about it, because I was quite sure that my views on the evidence would ultimately be shown to be correct. It was as clear as that. It wasn't a question of just having a view, I might be right, I might be wrong. But to be called a racist, that was something different. I just couldn't ignore it, whatever the risks, and I couldn't ignore it as a Jew. And I couldn't end my career and ultimately end my life with my family having their father depicted as a racist who did his best to ruin the credibility of a main witness in this case. So we took on the Observer, not an easy thing to do, and it took 2 years. It took 2 years before I secured a full apology and what could properly be called substantial damages. And that outcome occurred just before the public inquiry, the Macpherson inquiry, was launched. So that was quite fateful. In order to understand, I'm going to drop back again now for reasons I hope you understand. In order to understand some of the main problems which affected the criticism of the police, you have to realize this. Within 3 days of the murder, the family appointed Imran Khan to be their lawyer and their representative. And I assume that most of you have heard of him or know of him and know the position he has held. At that time, he had 18 months' experience. Not much, is it? But he took on the case, and I could speak a lot about Imran Khan, but it's all in the report, and I will not do that because it may not be too sensible. But something you need to realize about Imran Khan is exhibited from his own conduct. He decided that he, as an important liaison role with the police, would quite sensibly write to the police within a day of being appointed. Perfectly proper. So he wrote to the police, and he basically gave a list of requirements. I have no criticism of that at all. What's going on? What are you doing? Have you got any suspects? Quite a long list. Now, if you look at the documentary, and this shows how brilliant documentary makers can totally distort what happens by omission, by deliberate omission. If you look at the documentary, you have Imran Khan explaining very placidly, he's outwardly a very placid individual, that he wrote this letter, it was a fax letter, to the police, and I quote, the letter was unanswered. So he wrote another letter, unanswered, and then the camera pans. So if you listen to that, not knowing anything about the case, you would be entitled, would you not, to say, here's a lawyer representing this family who suffered this appalling tragic loss, who promptly and quite properly writes to the police asking for information, and the police don't bother to reply. And you would be entitled to think, how disgusting of police and how proper of Mr. Khan. Ladies and gentlemen, again, it's all there. Don't just take it from me. In fact, what happened is that Mr. Khan did send a fax on the Tuesday morning after the murder, setting out these requests. And he waited. Oh, he waited all right. He waited for 2.5 to 3 hours before sending the second request in the same terms. And then he waited 2 hours, 20 minutes on the same day before sending a phone call saying what is going on. 3 requests in that same day, and then 2 days later, a fourth letter threatening the police with a complaint if they didn't reply. In fact, we know this is a matter of record. The police did send a letter on that very first day, setting out, basically, this is more or less what we're doing. So that's just one example. Here's a man who decides to send all this documentation, one after the other, without, frankly, would you agree, without, frankly, giving the police any reasonable opportunity to reply to a long list of questions. Now, when the police in the inquiry criticized Imran Khan, because believe me, they did, they were criticized by Macpherson for using the word bombardment. This was not a bombardment. Indeed, Imran Khan said it wasn't a bombardment. He used a totally different phrase, his own phrase, ladies and gentlemen, sniper fire. Now, this is before Imran Khan had any reason to criticize police. It was the first few days. Later, he did have reason. So within a few days, this man appointed to represent this tragic family in the important role of liaison with police decided as a matter of tactics to use sniper fire. Well, you form your own conclusions about what that tells us about his agenda. But the inquiry itself, if you look at it, found quite a few things to query about Mr. Khan and his 18 months experience. First of all, he decided, apart from representing the family, he would also legally represent the only identification witness, Mr. Dwayne Brooks. Now, I stress there's nothing strictly wrong with that, but by golly, it's unwise, because you don't need to be a lawyer to realize that if you have something as sensitive as identification, any information which is improperly transmitted between witnesses and the identification witness will tend to nullify the quality of the identification. Makes sense. But he decided to represent the identification witness. And get this, again, it's fact, it's all in the inquiry. He took a statement, nothing surprising, from Mr. Brooks very shortly after the murder, in which Mr. Brooks stated, it doesn't matter whether he's right or wrong, it was black and white, that he, before the identification parades, had seen the statement of a witness. Mr. Khan decided he wouldn't tell the police this, what you might think is slightly relevant information about the main identification witness. He didn't even tell the representatives of the suspects when he launched a private prosecution that he had this statement. It was more or less dragged out of him at the private prosecution. And then he said at the inquiry he had no recollection of this statement. A few days, a week after the murder, he takes a statement from the main identification witness and he has no recollection of it. Basically, the inquiry also honed in on another very odd fact, that one of the identification parades where the main identification witness attended, there was a record, people talking about, I quote, a running commentary between Mr. Brooks and Khan's office. The police should not have allowed that to happen. I criticized that, but it happened. When he was asked about this at the inquiry, guess what? Couldn't remember. Very, very worrying memory loss for someone so young, I always thought. The inquiry also mentioned that although police themselves were heavily criticized, putting it mildly, various attendance notes and copies of letters written by Mr. Khan were, quotes, missing. He had, the inquiry said, quotes, a cavalier attitude to many missed appointments with the police. I mention this because the police were hammered for their lack of liaison quality, their failure to be sympathetic. They were really hammered by the inquiry, fairly or otherwise, but it's not just a one-way route. This man was the liaison. Police clearly have to deal with difficult people. You can't exempt them from their duties. But when you face someone like Mr. Khan, I do wonder aloud the difficulties that police had in trying to communicate with them. At the end of the case, at the end of the inquiry, when he gave evidence, the inquiry said, again I quote, Mr. Khan was ready to criticize and to contact the media more than perhaps was to be expected. Excuse me. They're putting it in quite twee language. That's Mr. Khan. Now, as you know, well, maybe you don't know, I've lived with this case for so long, I'm assuming things. After several years, it was clear that notwithstanding the efforts that for myself and senior police officers to get further evidence, we got nowhere. There was still the hope, but we'd got nowhere. And then the family decided that they were going to launch this famous private prosecution, which I hope some of you will recall. Now, it was quite clear to me they didn't have any evidence which I did not have. I mean, all the evidence they had, I had. And so we have this extraordinary picture in my years as a prosecutor, 25 years. I've never done this before. I've often spoken to lawyers, defense lawyers. I've never begged them not to pursue a course which would mean that their family would not get justice and the public would not get justice. I was on the phone at least twice, maybe 3 times, to Imran Khan, and the first time I spoke to him, I basically said, I can't remember exactly what I said, look, I do care about racism, I've suffered from racism, etc., etc. And Mr. Khan, whenever I spoke to him, was immaculately polite. I always find that strange because the minute we stopped speaking to each other, he was back on the media saying the CPS, i.e. me, was racist. And you would have thought that although he might speak to me, he wouldn't exactly be warm. He was charming, solicitous about my health, and the minute we got off the phone, CPS are racist. But I was begging him not to pursue a case, not to protect myself, I knew the evidence was hopeless, but to make sure that the Lawrence family and the public would get justice. I even went so far as to say, if you are determined to proceed on this private prosecution, just wait. I will give you and Michael Mansfield, the famous barrister, scourge of authorities, I will give you the evidence. I will show you what I'm talking about, so you won't just have my word, you can see it for yourself. Thank you very much, I'll consider it. And I thought he was going to consider it until about a week later, he decided we've launched the private prosecution. He wouldn't even wait for that. And over all these years, I've wondered about Mr. Khan and his liaison. I wondered what he told the family. Did he tell the family in any shape or form that he spoke to this otherwise faceless prosecutor who seemed a little bit out of the ordinary, someone who talks about suffering from racism, someone who's offering to show him the evidence? Did he tell them that? Did he tell them what any competent lawyer would know, that weak identification evidence does not go before the jury? I say that because on several occasions we saw the very sad picture, especially of Mr. Neville Lawrence, totally bewildered, saying we thought it was going to go to the jury, and if it went to the jury, we would succeed. But wasn't he told there wasn't a hope in hell's chance of it going to the jury? I just wonder what Mr. Khan told them. At the Central Criminal Court, as you know, the case was kicked out because the evidence of the only real identification evidence, Dwayne Brooks, was considered in terms hopeless. Exactly the same reasons I had forecast a few years before. His evidence had got even more befuddled, and it was kicked out. The attitude of the family to it being kicked out, well, they were obviously distressed. You can hardly blame them. I'll just give you 1 or 2 quotes about their views as to who was responsible for this. I quote from the report from Mrs. Lawrence about the private prosecution. This shows how bitter she was. Quotes, "It was clear from the outset that he, the judge, had come with the intention of not letting the matter proceed any further. We'd been warned that the state was against us, and it wasn't in the interest of anybody to let private prosecutions by black families succeed because it was set a precedent. It was clear that this was not a man who would allow us to present to the court the full story and let the jury decide." The jury couldn't decide for the reasons I've given you. The further quotes, "After the collapse at the Old Bailey, I realized there was no way that the state would have allowed us to have succeeded in terms, because that would have been a slap in the face for the government and the Crown Prosecution Service. What was coming across for me at the time was, who do we think we are? Some black family telling them that their justice system stinks." So that's why you've got these allegations against the state and against the judge. In fact, as you know, the inquiry basically totally confirmed the obvious, that the identification evidence was hopeless. As I say, no other lawyer, apart from Mansfield and Khan, have disagreed with that. Let me again jump back and just give you some idea of the problems in the case. Now, I haven't got time, obviously, to go to every single detail. It's a massive report, and there have been many criticisms of the police, and I'll deal with that generically. But I'm just going to give you some indications. You may know from reading about the case at the time, or even from looking at the documentary, that after the murder, the police received an awful lot of telephone messages, written messages, basically all saying words to the effect of the 5 suspects, it's 4 of them. The 5th suspect was mentioned somewhat late, so I'm not so concerned about him. It's them. The trouble was, this was information, it wasn't evidence. It was more or less saying, we've been told, or we believe it's these 4 suspects, or we've heard from someone who heard from someone who heard from someone else, it was them. That was valuable for intelligence. It was not evidence. You could not use that in court. Believe me, those of you who are lawyers will understand that. The only evidence, and it was hopeless, was the eyewitness evidence of Dwayne Brooks, which had to be discarded. Now, the inquiry hammered the police, and to this extent they were certainly partly justified in failing to arrest the suspects earlier than they did. The murder was on the 22nd of April. The arrests were made 6th of May, so it's just over 2 weeks later. And what the Macpherson report said was, because the police had all this information, that entitled them to arrest. And they're correct. You can arrest on suspicion, even though you can't put the information before the court. You can arrest and you hope you get the evidence. And on the day, the inquiry we were looking about, they said there should have been an arrest on the 26th of April, so about 4 days later. On the 26th of April, there was surveillance at one of the suspects' houses, and they saw one man leaving the house with what was described as clothing, although it couldn't be seen, covered by a black bin liner. So something was being carried out of the house 4 days later, covered by a black bin liner. Now that is suspicious. You may say very suspicious, but believe me, as criminal lawyers, you often come across evidence which seems suspicious and it amounts to nothing. It's not beyond the wit of man that even these moronic, vicious suspects might have thought of getting rid of anything they thought to be incriminatory the night after, a few hours after, a day after. The fact that they were seen carrying a black bin liner 4 days later, sure, suspicious. And on the 5th of May, the day before the arrest, another man was seen at another arrest carrying items of clothing. People do move clothing. Now, police are to be criticized because the obvious thing is, had they moved in 4 days after the murder, they might have got valuable forensic evidence and that might have secured justice for the family. I can't argue against that. What I want to actually try and persuade you, because I've got limited time, is that whatever you think of the police, whether you think that they were inept, there was nothing sinister about that. Because what the police said, and this is also not to be negated, is, had we arrested, having seen this black bin liner being removed 4 days later, had we arrested and found nothing, we would have had nothing. We didn't have any single witness to put these suspects on trial. So if we'd not found any forensic evidence, we would have put these suspects on notice that we were looking at them, and that would have made any subsequent covert operation less likely to succeed. It's an opinion which is not automatically to be rejected, that's all I say. So by all means, police to be criticized for that earlier failure to arrest, but it's not sinister. And having met senior officers, I repeat, I was convinced they wanted the prosecution to succeed. It wasn't a question of doing nothing, not bothering. After the collapse of the private prosecution, there was a coroner's inquest, and then we had this unique, in our lifetime, unique public inquiry based on a single case, the Macpherson inquiry. And I assume none of you, to tell me if I'm wrong, none of you happened to participate, be present in that inquiry. You would not have forgotten it for a moment. The evidence was heard in 1998 and the report was produced in 1999. Over 100,000 pages of evidence was before the inquiry. It took 2 months. And these 100,000 pages of documents, ladies and gentlemen, just concentrate on this a moment. Much of it was evidence which had never been put before any public inquiry before. In other words, virtually every single sensitive, secret memorandum, minute, correspondence involving the police and the Crown Prosecution Service and the Director of Public Prosecutions, it was handed to the public, apart from the redaction of one or two names for obvious reasons. Unbelievable. If we'd been, can you imagine police officers saying, just say what you want in a minute, and a few years later that will be put before a public inquiry? Unthinkable. And the important thing is that in an inquiry which, as you know, which I will deal with, was based on racism, can you imagine if Michael Mansfield had found a comma out of place, one little comment out of place which showed racism, he would have pounced. It was all there. It was all there for the public. It was there. And I was called to give evidence on behalf of the Crown Prosecution Service, and I decided very sensibly that I'd go along and have a look a few days before I was due to give evidence, have a look what was going on, because there were some very unpleasant things emerging from the papers. Now, I've appeared before the public in various guises since I've been a child, and with one or two exceptions, I've never been nervous before. The atmosphere at this inquiry was quite appalling. It was like, if you go back to English history, there's sort of crowds being invited to a public execution. I do not exaggerate. Witnesses were being baited for the entertainment of the public. There was a very hostile, emotional atmosphere, partly understandable, hardly controlled by the inquiry team. It really was rampant, the hatred and the anarchy almost, which I saw, which made me slightly concerned because I was still being portrayed as a racist, although I just won my libel case. So I had some very sort of mixed thoughts. Well, I've won my libel case. What's going to happen? The family was still, as far as I knew, saying that I was uncaring and a racist. Michael Mansfield would not have hesitated to pounce if he'd found any material. So when I gave evidence, and I was in the box for most of the day, in the morning, I was wondering, am I going to be attacked for anything I might have said or a comma out of place? And interestingly enough, no. There was not a single word, no allegation maintained. In retrospect, it might have been nice had he said words to the effect, look, I represent the family. I know there have been allegations that you didn't care, that you were a racist. I'm not pursuing that. I'm just attacking you on your decision to discontinue the case, and that I was prepared for. So we went hammer and tongs, Mansfield and I, a lot of high headlines in the papers about my clash with Mansfield, and his questions were perfectly proper. And putting it in sort of succinct terms, politely, he was saying I was an idiot, and I was saying he was an idiot, and that spent sort of about 2 hours doing that. And ultimately, the inquiry supported my views. But at one stage, I basically said, because I wasn't getting anywhere in persuading Michael Mansfield, I said words to the effect, I'm surprised that you're still maintaining the quality of the identification evidence was safe. It was hopeless. Oh boy. The minute I used the word hopeless, there was a noise, like a sort of nascent volcano beginning, and there was hostility from many in the public arena. And when shortly afterwards there was a lunch adjournment, I had to be escorted out. I was being harassed. There was an attempt to assault me, and not successful. And then perhaps 40 minutes of the most frightening 40 minutes of my life, all my CPS team and police team went off for lunch. Thanks, chaps. And they locked me in the CPS room with a phone, which I couldn't work because I was not very handy at those times about phones. And I was locked in the room, and for about 40 minutes, door handle was being tried, and people were knocking and trying to get in. I don't think they were there to congratulate me. So I held out for 40 minutes and thankfully went back. And then everything changed in the afternoon because a very clever staged question, which I had no notice of, was put to me by a senior barrister for the police. And they asked me just simply, it was more or less, well, just tell us your experiences, Mr. Young, with racism. I hadn't been any advance notice of that. Well, I just spoke from the heart. I don't know whether it was good or bad, but it was certainly sincere. And I remember basically saying that many Jews had attained very high position, be it in the law, be it in the medicine, be it in science, yet many of them felt a vulnerable strata. They remember anti-Semitism. They remember what happened to their parents, and we felt very vulnerable. And I was worried about my kids. And I remember saying, I was speaking to the black community. I wasn't speaking to Michael Mansfield. I was speaking to the black community. I remember saying, I don't care if you consider I'm an idiot. I just want you to know I cared. And the atmosphere totally changed. There was no barracking, there was no harassment. And when I left the inquiry at the end of the day, I didn't need an escort. And I'll always remember a smiling black lady. She came over to me, she put out her hand, and I took it, and we shook hands, and she said, "Mr. Youngwood, I want you to know I disagree with you about the evidence, but at least you cared." And those words were like nectar to me. I wasn't worried about the evidence. I knew I was right. So the mere fact she thought I was an incompetent lawyer, one thing, but she thought I cared. And so that ended my experience, quite a traumatic experience in the inquiry. And at the end of the day, when the report was published, I came out of it well. In which case you might say, well, why don't you shut up? There's been enough poison. Why say anything about this inquiry, which is critical? Because I feel I have to. I feel that justice has not been done, and justice has not been done in particular to the police. Just give you a quote, shows not just me, a quote from a review in the London Review of Books about the case. Quote, "The proceedings were conducted in a strange atmosphere, combining saccharine sentiment and naked adversarial aggression." The key finding of the report was that, the famous phrase, police, the Metropolitan Police Force, were guilty of, quote, institutional racism. And if I had time to give you bits of paper and give you an exercise and say, tell me what you think institutional racism means, I bet most of you would make an absolute mess of it. And I think you would probably say, tell me later in question if you disagree, institutional racism. Well, racism means someone who's hostile, who hates other religions, other ethnic backgrounds, yes? So institutional racism is an institution who hates other people, whose policies are anti-other people. Is that a fair comment? I think most people would guess that. But that's not the definition of institutional racism. The definition which this report adopted of institutional racism is as follows. I'm not going to repeat it, it's a bit of a mouthful. Here it is. The collective failure of an organization to provide an appropriate and professional service to people because of their color, culture, or ethnic origin. It can be seen or detected in processes, attitudes, and behavior, listen, which amount to discrimination through unwitting prejudice, ignorance, thoughtlessness, and racist stereotyping which disadvantage minority ethnic people. Had this inquiry pointed out, I think, an essential truth, that you can hurt people when you don't intend to. You can hurt people and offend them in ignorance. If we try and communicate with other religions, unless we are experts, we're bound to ask a question which is probably asinine, and they may take offense. But to be called in any shape or form a racist, that to me is unjust, and it dilutes the very meaning and evil of racism. We all know what real racism is. You can still see it. You can still see black players being abused on football pitches and monkey noises being made. That's racism. We know as Jews what real racism is. And yes, by all means, let's accept we can offend other people without meaning it. But please, I say, and others say, do not dilute the meaning of racism in the last century and nowadays by saying you can have racism when you don't really mean it. And I'm not the only person to be concerned. Many people are concerned about this. And one person who was hammered, but who was very worried, was Sir Paul Condon, who was then the Commissioner of Police. And he was very worried. He was being compelled, pressure was being put upon him to accept that the police were racist. And he basically said that he was not happy with this. Let me just see if I can find the quote. My handwriting is awful. Yes, here we go, 6 more. This is what Sir Paul Condon said, and I totally agree with him. You are free to disagree. If this inquiry labels my service, the Metropolitan Police Service, as institutionally racist, the average police officer, the average member of the public will assume the normal meaning of those words. They will assume a finding of conscious, willful, or deliberate action or inaction to the detriment of ethnic minority Londoners. I actually think that use of those two words in a way that would take on a new meaning to most people in society would actually undermine many of the endeavours to identify and respond to the issues of racism which challenge all institutions, and particularly the police, because of their privileged and powerful position. I totally agree. You're free to disagree. The inquiry did not find a single police officer overtly racist. Just take that in. All these years of allegations, and some of these officers may well have been racist. I mean, as a matter of statistics, there are racists in the police force, but not one of them was found to be overtly racist. Not one. But the whole of the Metropolitan Police was considered to be institutionally racist because of the implementation of policies and the effect of their policies. Let me just give you 2 or 3 examples of how the police were indicted for institutional racism. And again, it's a matter of record. At the hospital where Stephen was taken, almost certainly dead by the time he arrived at the hospital, some police officer had the horrible task of breaking the news to the family. Yeah? Now, I've lived long enough to know that there are some people are just lousy at communicating. Some people are natural, and some people are lousy. And that involves doctors, and it certainly involves police. There are some people who are not good at breaking bad news. They're not automatically racist, are they? This is what the conversation which took place at the hospital. And I'll try and say it in a flat tone, not trying to give any sort of advantage. The officer basically said to the Lawrence family, this is the quote, "We've got a young lad in there, he's dead. We don't know who he is, but we would like to clarify that point. If it is not your son, then all well and good, but we do need to know. I'm sure you would like to know as well." Not very good, is it? But racist? I say racist because this officer was found to be racist, not deliberately racist, but racist in the way he'd given that information. Let me just quote from the report, so I'm not making sure I'm not making it up. This officer, Inspector Little, he'd worked, I quote, in multicultural societies and areas throughout his service and believed that he treated everybody in the same way. His lack of sensitivity and his inaction, particularly at the hospital, betrayed conduct which demonstrates inability to deal properly with bereaved people, and particularly those bereaved as a result of a terrible racist attack. He failed to deal with the family appropriately and professionally. This was unwitting racism at work. Really? Did this inquiry have evidence that a week before he dealt with a white family and was a totally different man, oozing sympathy? This was the only evidence in which an inspector was considered to be guilty of unwitting racism because he was a relatively poor communicator. Again, I leave that to you to see whether it's fair. Another criticism, I haven't got time to go in detail, was the officer in charge of the case was complaining about Imran Khan, that he was trying to liaise with the family, but Imran Khan had stated as a matter of record that every approach to the family must go through him, Imran Khan. And it was considered that this superintendent was guilty of patronizing against a black lawyer. The question to be asked is, had this superintendent found a left-wing white lawyer who's basically being difficult and using sniper fire, would his attitude have been different? I don't think so. But that's the type of evidence, ladies and gentlemen. It's just symptomatic of how police were considered institutionally racist. Another extraordinary fact about this inquiry is that the 3 main witnesses were Dwayne Brooks, the only identification witness, and of course Mr. and Mrs. Lawrence. A multi-million-pound inquiry which the Lawrences had been calling for. Not one of them gave any real oral evidence. Not one. There was a famous speech by Mrs. Lawrence in which she said, after about the 4th question, by perfectly competent fair counsel, "Am I on trial here?" No, of course she was not on trial. She had asked, she had begged, she had made allegations. Surely it would have been only fair and proper for her to be asked questions, just in case she'd got some things wrong. Because, believe me or not, police counsel, all very experienced, would hardly have dared be offensive to her. You can imagine what would have happened. There would have been a lynch mob. but they refused basically to answer any questions. And this raised great concern amongst many public writers and commentators. They talked about not only the atmosphere at the inquiry, but many things which concerned them. The Independent broadcast an article saying that, as far as they knew, Imran Khan and Michael Mansfield, the family lawyers, were going to be criticized in the report. If you read the report, the criticism is always there, fact after fact. They don't use critical language, but it's all implicit. No direct criticism whatsoever was made of Imran Khan and Michael Mansfield, so much so that many commentators were asking quite publicly, was this because they were afraid of upsetting the family? A multi-million-pound inquiry, and an inquiry which is afraid to follow their noses and make some criticisms. And let me just give you a few quotes from other writers before I come to the last few minutes about their concern about the inquiry. First quote, a review by a lawyer in the London Review of Books. Quote, by the end of the Macpherson inquiry, it was sometimes difficult to know whether the most important issue was investigating an unsolved murder or placating the victim's mother and her constituency. Another quote from that same review. The fact that the inquiry did not consider it necessary to hear from the Lawrences or Brooks suggests that it had already drawn its conclusions before considering the evidence before it. It isn't often, they say, that you see civil liberties lawyers, Khan and Mansfield, braying for the dismantling of procedural safeguards designed to protect defendants or victim-led justice fueled by an upmarket media onslaught. One final quote from this review. There are now two Stephen Lawrences. The first, the murdered 18-year-old victim of racism. The second, a cultural balloon with Stephen Lawrence's image on it, a balloon so large there is barely any space left in which to think objectively about Lawrence, his murder, and the subsequent investigation and inquiry. After the report, most people, I think, were guilty of intellectual dishonesty. They were afraid to speak out. I really think there was cowardice here. A few people did speak out, and my attention was drawn to a report which skewered the inquiry by a sociologist who I'd never heard of, it's not my field, called Norman Dennis. Now, Norman Dennis is interesting because when I read that he'd skewered the report, I thought, well, maybe he's just some sort of right-wing sort of character who's got it in for them. No, Norman Dennis, he died a few years ago, he was born in Sunderland, a lifelong Labour supporter. So on the face of it, he's not the sort of material who would be automatically hostile. I just want you to read you a little bit from his summary of his report. Other people disagree with him, but his is the most compelling report. It was published in 2000 by the Institute for the Study of Civil Society. I quote from the summary. The public inquiry set up under the chairmanship of Sir William Macpherson sometimes had the appearance of a judicial proceeding, but in many crucial respects, it departed from practices which had traditionally been regarded as essential in English law. Rules of evidence were modified and witnesses were harassed, both by the members of the inquiry team and by the crowd in the public gallery. Representatives of the Metropolitan Police were asked to, quote, confess to charges of racism, even if only in their private thoughts. They were even asked to testify to the existence of the racist thoughts of other people. It is part neither of the English judicial process nor of English public inquiries to put people on trial for their thoughts. The proceedings bore some resemblance to the Stalinist show trials of the 1930s. I think I'm being critical. However, no evidence of racism on the part of the police was ever produced. There was no attempt to show that the Metropolitan Police was racist in the sense of being formally structured to put members of ethnic minorities at a disadvantage, nor was there any evidence produced that individual officers dealing with the murder of Stephen Lawrence had displayed racism. In spite of this, the Macpherson report found the Metropolitan Police and British society generally guilty of institutional or unwitting racism. This claim was justified by referring to other bodies of evidence to that collected at the public inquiry, including a list of publications consulted, which in many cases had nothing to do with the Lawrence case and sometimes nothing to do with the UK at all. The Macpherson inquiry, unable to find evidence of racism, produced a definition of racism that at first glance absolved it from producing any. It switched attention in one direction, away from racist conduct and towards organizational failure. The ineffectiveness of the police had purportedly been demonstrated. That ineffectiveness concerned a racist crime. Therefore, the ineffectiveness was due to police racism. It switched attention in the other direction, away from observable conduct, words or gestures, and towards the police officers' unwitting thoughts and conduct. But how could the Macpherson inquiry know what was in an officer's unconscious mind, except through the failure of the police to be effective in the investigation of a racist crime? This definition puts charges of racism outside the boundaries of proof or rebuttal. The Macpherson report has had a detrimental impact on policing and crime, particularly in London. Police morale has been undermined. Certain procedures which impact disproportionately on ethnic groups, like stop and search, have been scaled down. The crime rate has risen. Nevertheless, the Macpherson report has been received with almost uncritical approval by pundits, politicians, and academics. It is still routinely described as having, quote, proved that the police and British society are racist. In my final few minutes, I just want you to bring update with my personal story. So I'd won my libel case, I'd given evidence, I'd spoken to the black community. Presumably, I say presumably, the Lawrences were given some information by their wonderful liaison lawyer, Mr. Khan, about what I'd said. Did that change anything? For some years, I wasn't sure, until I got the evidence, because we can't be neurotic. I mean, we Jews tend to be neurotic, but in my case, I was entitled to be neurotic. Did they still think I was a racist? A year or so after the Macpherson report, there was, as you may have known and seen, a very, very successful play, like a docu-play, called The Colour of Justice. It played at the Tricycle Theatre in Kilburn and then transferred to the West End. I don't know if any of you saw it. What was interesting is that yours truly featured at the end. I was in it, so I crawled along with my dear wife and sat there very uncomfortably and saw an actor called Thomas Wheatley play Howard Youngwood. It was quite dramatic because there I was saying the evidence was hopeless and all my attempts to stop the private prosecution, all a bit emotional, and it seemed to make good drama. And it was so successful that the play transferred to the West End. And this is where I got neurotic, because when it transferred, I disappeared. Not an iota of Youngwood remained. Well, I thought, well, is there maybe a dramatic reason for that? I've done lots of plays myself, and possibly, but it was really pushing it because it was successful and I had something to say and it's quite dramatic. And so for a year or two, I didn't know, but I felt a little bit neurotic until I came across on the wonderful internet an interview with Thomas Wheatley, the actor. Now, Thomas Wheatley has been in lots of things. He's been in James Bond. He's also played the commandant at Auschwitz, so quite proper for him to play me, wasn't it? And he basically was interviewed. Excuse me, let me just find the article. And he gave an interview, and he explained what had happened. Oh, there we are. No, can't find it. All right, I'll have to speak by heart. Wheatley made it quite clear that when the play transferred to the West End, pressure was put on the director by the Lawrence family and their supporters to get rid of me. It's all in the article. Why? Because they had, as he says, an issue with me about race after all this time. And although Wheatley felt uneasy, in fact, he actually wrote to the director saying, this character Youngwood's got something to say. After all, he said the evidence was too weak, and the director pulled me. It's the only case in all the plays he's been in this type of play where someone has been sacked from the play. That was me. And then that was the result of the Lawrences still feeding this poison because I had that's all I'd done. I'd discontinued the case and then worked at Billy O to try and get evidence. And then I saw the documentary in April, and I appear fleetingly at the end of the first episode, and I merely explain why the evidence was too weak, which is hardly controversial. I can't tell you everything I told them when I was filmed for hours. They came to my home. I was filmed for hours. I spoke about everything about the case, and they didn't have time. They didn't have time to include anything about my experiences, even though the documentary was based to reflect the experiences and feelings of key players in this. And so I just end with this thought. I was removed from the play. I was removed from essentially the documentary. And I think the only reason is that when one looks at it on any objective basis, my role over many years, my evidence, my experiences did not fit into an agenda where racism is the leitmotif, and out of that foundation myth you have heroes and villains. And once you establish the heroes and villains in the case, it's very difficult, isn't it, ladies and gentlemen, to shift that. Anyway, that's my story. Thank you for your attention.
Do we have any questions? Yes, please choose your words fairly carefully because we are recording it.
Without prejudice. You touched on your mental state earlier on. On a high-profile case like this, how did this affect you and your family? And also the question about the risk of violence coming into the equation. You must have been very uncomfortable going back and forward from the office and knowing that perhaps people were going to attack you.
As far as I recall, I wasn't worried about being attacked in the office, except by my senior CPS lawyers who considered me a backbencher. During the libel action was very traumatic. I didn't have time to say, and thanks for a question at all. In a Jewish audience, asking a question is quite an achievement. I decided to take on The Observer because I was being depicted as a racist, and it's something which was Jewish in me because, as I think we all know, Judaism stresses the harm that can be done from tale-bearing and false reports. I mean, the Talmud basically says that to destroy a person's reputation is worse than taking away his life. And in those 2 years, I felt that was very, very real. So my fear was not of physical violence. My fear was that if I lost the case, I would lose not just my reputation. I use the word just carefully. I would probably have lost my home, and I tried to transfer everything to my wife. She still got it. Who knows what would have happened? I was at risk of losing everything, my reputation. That was my fear, not physical violations, but the mental trauma was of my reputation. A Jew who was basically going out to ruin a case for a poor black family, a hypocrite and a liar. That was what worried me, not physical violence.
How do you account for Imran Khan's unacceptable behaviour?
Thank you for
What's
trying
his motivation, do you think?
I haven't lost all my skills, Geoffrey, and there's no way I'm going to answer that because I hope I've given enough information, and for those who are interested, it's all in the report. I want you to make up your own minds because lots of people have different agendas. It would be stupid of me to simply say, this is what I think Imran Khan was up to. What I've tried to do is not simply say, this is what I think he was up to, but rather give you the facts, the evidence, and please make up your own mind. Sorry? Sorry about that. No, I'm not.
Since then, 2 people have been convicted of his murder. What evidence, what happened to change things?
Well, as I touched on briefly, when I discontinued the case, there was a hope we would get evidence. I mean, I still think to this day there are 2, 3, maybe 4 people, you remember 1 or 2 of the names of these confounded women, who could have come forward and given evidence, and they didn't. So subject to some sort of Damascus conversion, they're probably not going to come forward. The other hope was that forensic evidence would develop, and this is what happened. In about 2004, 2005, DNA evidence had advanced so that minuscule specks could be the subject of analysis, and that was the subject of the most careful analysis. and that was sufficient to tie in two of the original suspects in the case. And the interesting thing is that once they got that DNA evidence, then, and only then, were they able to bring in this appalling tape, an audio tape of these suspects using the most appalling racist behavior. In other words, by itself, the tape would not establish identification. Identification was established through DNA of two of them. When you had this evidence, you had identification plus wicked racists, and that was enough. So it was developments, as we always hope for whenever we discontinue a case.
Thanks. Would you say that in the light of those events and subsequent events at the moment, where we as Jews feel very, very strongly vis-à-vis Corbyn, etc., that the CPS has perhaps changed its attitude at all? And when I say that, I'm referring to a particular case that the Campaign Against Anti-Semitism wanted to bring against, I can't remember the fellow's name exactly, who 2 years ago in the Al-Quds March deliberately conflated the Grenfell problems with that of the Jews. And as a result, the Campaign Against Anti-Semitism deliberately wanted to bring a case, and they were advised, I use those words perhaps advisedly as it were, not to bring the case, and the CPS would then take it up. As I understand, the CPS deliberately or otherwise took the case on and then refused to continue it. And I understand now, perhaps you're more aware of this, that the Campaign Against Anti-Semitism has brought it back and is now bringing a private prosecution against this gentleman.
Look, I hear you, I hope politely, but I've been out of the CPS since 1986. How can I answer that question unless I see the evidence? I can understand the concern about it because there's been lots of criticism about the CPS not following through with prosecutions. I simply can't answer it without seeing the evidence. All I'd say is, I mean, it touched on tangentially that one of the detrimental effects of the Macpherson inquiry is to make things, in a sense, more difficult because we are in a realm of political correctness gone mad and Orwellian control of language, which has never been seen before. What worries me, and I know I'm not answering it directly because I can't, what worries me, and I said it right from the start when I spoke about this case, is that if you can be guilty of being described in any shape or form as racist through thoughtlessness, when you don't mean it, that's going to deter, will it not, most people from trying to form helpful links with other communities. If I was going to go and speak to, I don't know, a Hindu or a Buddhist, and I was asking some questions about their religion, I don't know much about their religion. I'm bound to get something wrong. And if they were to take offense, I would apologize. But if they called me a racist, I'd be very, very hurt about it. It's deterred it, and at the same time, it's brought out this crazy political correctness. I'll just give you an example. A very good friend of mine, a very respected judge, a month ago or two, told me in shul that he'd written a judgment and paused when he'd said, the situation is not, quotes, black and white. And he put, can I say that? And he decided he could. He could. Another senior police officer is subject, as I understand it, to disciplinary proceedings in charge of an anti-corruption squad at New Scotland Yard, where he was trying to persuade them that their actions are to be above criticism and use the phrase whiter than white. He's subject to disciplinary proceedings now. We've had allegations that the London Fire Brigade after Grenfell is institutionally racist because allegations were that they were ineffective. Imagine the police were ineffective. We are in a crazy world. That's the real harm. I'm sorry, I can't answer that specific question. I don't know what the evidence is. I understand your concern. Oh, long time.
In the case that was mentioned here, the CPS took over the private prosecution and then ended it. Why wasn't it in this case that the CPS took over the private prosecution? Has the law changed?
No. You have asked perhaps the most interesting question of all, and a question which I hope I would never have been asked, because you're quite right. Where private prosecutions are relatively rare, certainly for murder, not unknown, but they are taken, sometimes for very little things. That people have grievances, they'll take a private prosecution. Crown Prosecution Service, you're quite correct, sir, have the right to take over a case, not just for no reason, where there's no evidence or it's not in the public interest. One of my many nightmares, which I put into writing, was what was going to happen if the team defending these racist suspects went to the Crown Prosecution Service and said, please take over this private prosecution. The evidence was exactly the same. On the face of it, I would have had to drop it. And here is where I behaved like a really fiddly lawyer, because although I think I'm brave, I'm not totally stupid. And I said to those above, I said, basically, there's no way I'm going to take over this private prosecution, however hopeless it is, and drop it. Because the public perception, well, you just imagine, the public had been fed this story that we were racist, uncaring, everyone was racist. If I'd taken it over on proper grounds and said the evidence is not there, I'm dropping it, the public would have just, there would have been an avalanche. The only lucky thing I got out of that is that the team defending these suspects were sufficiently astute to know they didn't need me. The evidence was hopeless and they got the acquittal. They didn't need me. But your question's very perceptive, and that was one of the nightmares I had.
I don't think you will like this question. There can be nothing more tragic than to lose a child, but under these circumstances, how much greater the tragedy. Subsequent to the death of her son, Doreen Lawrence worked continuously and in many ways. Do you think that the establishment ennobled her to show that there was no institutional racism?
I don't know. She was a redoubtable woman who'd fought for justice. I think her accusations were, to a significant degree, unfair and not made out. And I certainly think there's evidence that people in authority were so concerned about racial problems in this country that affected their actions. And this went as far as this multi-million-pound inquiry. It's not just me. Commentators, I'll give you some of the quotes, are basically saying, what's their agenda? Is it to placate this anguished woman, or is it to actually find the facts? The ennobling of Doreen Lawrence is another thing. Lord knows she'd worked in the field of race relations, and no doubt that is totally deserved, and I wouldn't say anything more than that. It's an awkward question, as I know. But there are many other concerns about the agenda, but her own actions, her own subjective feelings. It was suggested it's patronizing for anyone to suggest that she was under the influence of anybody. That's what the inquiry is, patronizing. It's not patronizing. If you're vulnerable, you are subjective to influences. She was surrounded by people, not necessarily all well disposed to get at the truth. She was a vulnerable lady, a very strong lady, but still vulnerable. And you can see from the way that even after all these years, she wanted to get rid of me, notwithstanding what emerged, that the poison is still there, I fear.
Howard, it's a number of years since we met on holiday. We had the privilege to meet you and Naomi in Eilat, I think. It's probably more or less about the time that you have been focusing on this evening.
God, you know how much I ate then?
Well, now we know why. But I just wanted to, on behalf of everybody present, to thank you for this absolutely simply brilliant lecture this evening on this subject, which one can understand what this has done to you over the years, both as a professional and from a family point of view. It must have been a horrifying experience at certain times, and from that point of view, you will be entitled to everybody's deepest sympathy. On behalf of everybody present, traditionally, we're making a presentation to you. Enjoy this, and we hope to hear from you perhaps on subsequent occasions, maybe different cases, because this was really a treat for all of us tonight. Thank you very much.
Thank you all much.